always expect the reading of a will to bring answers and peace. But what happens too often is this. Everyone is exhausted after the funeral. They gather around a dining table. Someone opens a will, and within a few minutes, people are confused, hurt, or even angry. Questions start flying. Why did she do it this way? Why is my name missing? Who is supposed to be in charge of this? The document that was meant to guide everyone through a hard time ends up creating tension instead. A lot of tension comes from a handful of very common mistakes. The good news is that those mistakes are completely avoidable. In this video, I want to walk you through 5 mistakes with wills that cause family drama and how better planning can help your family avoid a scene around the dining room table. Before I go further, I want you to know that this is a general information, not legal advice for your exact situation. Every family and every state is different. You should always talk with an attorney about your plan. My name is Kim Clenney, and I'm an attorney in Montgomery, Alabama, at Clenney Palmer Attorneys at Law. My law partner, Deborah Palmer, and I have been practicing law for about 25 years, helping Montgomery families with wills, trusts, and estate planning. Now I want to walk through those mistakes one by one in plain language. The first mistake is relying on a generic online form instead of getting legal advice. It's very tempting to search for a simple will download, something that looks official, fill in a few blanks, sign it with whoever's available, and then check, get a will off your list. On the surface, that feels quick and convenient. Underneath, several things can go wrong. Language that work in one state can create problems in another. A form you find online may not fit what Alabama law requires. It may leave out important roles like who is in charge of your estate, who will care for minor children, or who will manage money for children or grandchildren. Sometimes the wording in a generic form clashes with how your property is actually owned, or with the beneficiaries listed on your life insurance and retirement accounts. Your will may say one thing while a beneficiary form quietly sends the money somewhere else. You walk away thinking, I have a will. In reality, the document does not match your situation. That confusion shows up later as delays, questions from the court, and arguments inside the family. This is one reason why sitting down with an attorney matters. A will is not just a name on a page. It needs to work with state law and with the rest of your financial picture. The second mistake is never updating a will when life changes. Think about what can happen in 10 years. People marry, people divorce, babies and grandbabies arrive, a spouse or child passes away. You might move money, buy or sell a house or a horse, start a business or retire. Families blend and shift. If your will stays exactly the same while your life changes over and over, the document can drift from what you really want. An ex-spouse may still be listed where a current spouse or a child would be. A new grandchild may never be mentioned. The person you chose to handle your estate years ago may now have a serious health issue or may live far away. Many people write a will once, tuck it away, and never look at it again. By the time anyone reads it, some of the details no longer fit. That often leads to confusion and hurt feelings. A helpful habit is to review your will after major life events every few years. That review does not always mean starting from scratch. Sometimes you only need a small update. The important part is keeping your written will plan aligned with your actual life. The third mistake is making decisions that will surprise people without offering any context. You have choices. You can decide how property is divided. You can treat children differently. You can give to charities or church. You're allowed to make those calls. The conflict tends to show up when those choices arrive as a complete surprise. Imagine two adult children sitting side by side. One receives a much larger share, one receives less, or is left out. Even if you had a very good reason for that, silence around those decisions create pain. People start filling in the blanks with their own story. Maybe I mattered less. Maybe there were problems nobody told me about. You are not required to share every detail of your will with your family. In many situations, a simple explanation makes a big difference. Maybe you helped one child more during your lifetime and you're balancing that out. Maybe one child is taking over the family business. Maybe you're trying to protect someone who struggles with addiction or spending. When you work with an attorney, you can talk through these situations and decide how much to include directly in the plan and whether a brief letter or conversation would help your family understand your choices later. The fourth mistake is failing to name backups. A will does more than list who receives which assets. It names an executor to handle your estate. If you have minor children, it can name a guardian to raise them. It can name someone to manage money for children or grandchildren until they reach an age you feel is appropriate. Many people choose the first person for each role and then stop. Life is unpredictable. The person you choose first may pass away before you. They may move across the country. Their own health, work, or family situation may change. If there are no backups named, the court has less guidance from you when that person cannot serve. A judge may have to make a guess about who should step in. Family members may disagree about who is best. That disagreement can turn into real conflict in a season that is already emotional. When I meet with clients, we talk about backup choices. If your first pick cannot serve, who would you trust next? Who is organized enough to manage paperwork and deadlines? Who would care for your children in a way that reflects your values? Putting those backup names in writing gives your plan more stability. The fifth mistake is never talking to the people who are named in your will. Talking about death and estate planning is uncomfortable. Many people avoid it altogether. The will gets drafted, signed, and put away in a safe drawer. Nobody mentioned in the document knows about it. Then something happens. You pass away. Your family is grieving. Someone finds a will. The person you named as executor had no idea they were chosen. The person named as guardian has never pictured raising your children. The person you trusted to manage money for your kids or grandkids finds out about that assignment on one of the hardest days of their life. Even when your choices are wise, the surprise can trigger panic and pushback. It can also slow down the entire process. You do not have to sit with everyone sit everyone down and read the will line by line. In most families, clear, private conversations are enough. You might tell the person you chose as executor, "I named you to handle the legal and financial side when the time comes. Here is where my will is kept, and here is the firm that helped me." You might tell a potential guardian, "If something happens while the kids are young, I would want them with you. I put that in my will. Can we talk about whether you are comfortable with that responsibility?" You decide how much detail you want to share. The goal is to avoid letting someone find out about a major responsibility for the first time at the funeral reception. Even something simple like telling your family where the original signed will is stored can prevent a lot of stress. A will nobody can locate can create almost as many problems as having no will at all. If any of that sounded familiar, don't panic. A lot of families are in the same place. The encouraging thing is that every one of these issues can be addressed. You can sit down with an attorney, review what you already have, and either update it or create a new plan that actually fits where you are now. Getting your will and estate plan in order tends to lift a lot of weight off your shoulders because you know the people who you love will not have to guess what you wanted. Right now, we are offering a free consultation for wills and estate plannings because we know this has probably been sitting on your list for a long time. During that consultation, we will talk with you about where you are today. We will ask about your family, your home, your accounts, and any special situations that worry you. We'll look at any documents you already have, if there are any, and we'll talk through what you want to happen for your loved ones. In one conversation, we can review where you are, discuss what you need, and map out the simplest way to get there. If you live in or around Montgomery, Alabama, you can book your free consultation while we have spots available. The link is in the description of the video, along with our office contact details. I want to leave you with this thought. A will is more than paperwork. It is a set of instructions for your family on the hardest days they will ever walk through. A few careful choices now can remove a lot of confusion and conflict later. If this video helped you see where your plan may need attention, tap the link button so more people can find. Share it with someone you know that might need to see this video. I am Kim Clenney with Clenney Palmer, Attorneys at Law in Montgomery, Alabama. Thank you very much. I'll see you in the next video.